Hey, stick around and learn what workers' compensation is all about. Hi, I'm Dennis Vandergast. Being an attorney, I know that the law can get confusing. In Legal Squeaks, we provide you with useful and easy to understand squeaks of information on legal and consumer issues that you can apply in your daily life. Let's get started. Hi, everyone. Welcome to Legal Squeaks. I'm your host, Dennis Vandergast. And before I introduce you to our guest for today, I want to remind you all that if you haven't already done so, please be sure to subscribe to Legal Squeaks on your favorite podcast platform. It's free and it's easy, and we'd be so grateful if you would do that. So today, we're going to talk about workers' compensation. And I'd like to introduce you to Clarissa Reitveld, who is our de facto head of Iowa workers' compensation, the head of our workers' compensation department with respect to Iowa cases. Clarissa is an attorney with Vandergast Law, and she's been here for just about a year. Is that about right?
Just over a year.
Just over a year. So she's been a great addition to our team, and she's going to hopefully tell you everything that you need to know about workers' compensation, but was always afraid to ask. So, Clarissa, have at it.
Thanks. Thanks for letting me come onto your podcast. I've always joked that I should have a podcast.
You probably should. Yeah.
Maybe. So work comp or workers' compensation, sometimes it's called workman's comp, whatever, same principle, is basically the grouping of laws in, individual states that protects an injured employee. So, if you're hurt on the job and, you need medical care treatment or something along those lines, then your employer should, and it makes sense that they do this, but should cover those injuries and that treatment because it happened while you were working. And so it doesn't cover every injury, but it covers, I would say, the majority of injuries. But there are some factors that you should know, or an injured employee should know. And these are just the most basic things. So there needs to be an employer-employee relationship, and the injury needs to, and this is a term of art, but it needs to arise out of and in the course of employment. Mm-hmm. So the first thing that I think I would want to tackle is that employer-employee relationship, because I think that's where a lot of confusion comes into play. Most employees can be most people can be classified as either an employee who receives a W-2 or an independent contractor who receives a 1099 at the end of the year. If you're an employee, you receive a W-2, there's typically not going to be any question of whether or not you're covered by the employer's work comp insurance plan. It's when you get to those employees or those people who are not technically employees for tax purposes, they're receiving that 1099, they're an independent contractor, that we get into this area where you may or may not be eligible under that person or that company or that employer's work comp plan. And so there are different factors to determine that. It's in Iowa, I think there are 8 factors that we use to decide, yes, you're classified as an independent contractor for tax purposes. You get a 1099 at the end of the year, but you might actually be misclassified as one of those independent contractors, and you actually are an employee. And so you would be covered under work comp insurance. And I think probably the most common one that I run into in my practice are truck drivers. Most truck drivers are receiving those 1099s. They feel like they're independent contractors. Their employers tell them that they're independent contractors. But when you actually look at their job duties and who controls how they actually do their job, we find that they're actually employees and so should be covered under work comp.
And Clarissa, isn't that exactly one of the biggest factors, is who controls what you do, what your duties are, your responsibilities? Isn't that a big factor in determining whether or not you are an employee versus an independent contractor?
Absolutely. Absolutely. If you are, a lot of truck drivers, and I'm just using that because that's the most common example that I have, but a lot of truck drivers are independent contractors or are called that, but they go to a specific site, to pick up their load. They are told how to do that, where to go, when to do it. They don't really control the way that they're doing their job. There's somebody telling them. And so they're probably not an independent contractor, at least for work comp purposes.
So folks, if you are working under the misunderstanding or the misapprehension that you are actually an independent contractor and not an employee, and this type of situation arises where you're hurt while working, what Clarissa is basically saying here is, don't just presume that you are not going to be entitled to workers' compensation benefits because you are an independent contractor, because indeed you may not be an independent contractor. You may have been misidentified as such, if whether it's in the context of the trucking industry or some other type of job. If the person in charge, so to speak, is dictating when you report for work, how you conduct your business, the job duties, the responsibilities, etc., then there's a good argument that you are actually an employee and therefore entitled to workers' compensation benefits. So don't presume that you're not just because somebody has told you you're not. And if you have questions, obviously, reach out and ask an attorney to see if they have a difference of opinion.
Yes, absolutely. The other sometimes exception to who is an employee and who is not, or who would not be covered, is in some states, not all states, but some states, if this is a very small business, so if there are just one or two employees, then that business may not be required to have work comp insurance for their employees. So that's another reason you might not be covered. But again, just reach out to an attorney. I mean, you have nothing to lose by asking, and potentially everything to gain. And
even in that instance, in that example, as Clarissa points out, in some states, the employer, depending on the state's requirements, the employer may not be required to carry workers' compensation insurance. However, if that's the case and you're injured while on the job and you are an employee by every other definition, correct me if I'm wrong, Clarissa, but they can still be forced to pay for compensation. It's just not being covered by a work comp insurance coverage.
Yeah, it just might be under a different part of that state's laws.
Okay. And certainly in that instance, you can, if you can prove negligence, you can get a recovery that way. Typically, negligence is not necessary to be proved for workers' compensation. And we'll get to that, but that's one of the big distinctions between work comp and your typical negligence cases, is you don't have to show any fault in order to get a recovery.
Yes. Yep. And then just the last one, and just really briefly, if you are the owner of a business, perhaps you have a sole proprietorship or something along those lines, you may not be covered. So if you're injured while you're, performing your job duties, depending on whatever coverage that you may or may not have, you might not be covered by your state's work comp laws. So again, just something to check out look into that policy coverage and see what it says.
Okay.
So then the next part is arising out of and in the course of employment. So this is something that is the subject of loads of case law, legislation. But essentially, if you are, doing your job, so arising out of, it's two parts. So arising out of is it relates to your job. So you just have to, show and whether or not this is related to your job duties, something that you would have been doing, in the course of your employment or arising out of your job, could cause this. And it's just that causal connection. So X is related to Y or has caused Y. Mm-hmm. And so I'm sorry, go ahead. No, go ahead.
A good example that I know we come across quite a bit in the practice is somebody, let's say, who is maybe either going to or coming from work, and they're in an accident, or it might be that they're even on the premises of their work. They may be walking to from their parking lot to the building where their work is housed, and they slip and fall. And then the question comes up, okay, was that arising from their work? Was it in furtherance of their work? Sometimes no. So even though they may have been technically on the clock, sometimes they also may have been diverging from something that was work related. So for instance, maybe they don't get maybe they're driving, for instance, from one location to another, and they are on the clock technically, and they're doing something all day long that's related to their work. However, for a moment, they have to stop at their house and pick something up. Well, that's a divergence from their employment. And again, if they are injured, they may not be covered because that's not arising from or in furtherance of their employment. So, those are a couple of examples where there might be a question that arises as to whether or not you're going to be entitled to workers' compensation benefits.
Exactly. And that second part is in the course of. So it's really the time, place, and the circumstances of the injury itself. Did it happen while you were employed and while you were working? Was it where you would have reasonably been to do that job? And were you doing work duties? And I think, so that's really like the time, place, circumstances. But what has really been interesting in the last, I'd say, 18 months is with COVID and the pandemic, we have switched or we have transitioned to much more remote work. And so people are working in their home offices. They're not working in that traditional office setting, but people are still getting injured. And so then it becomes a question of, does that maybe home office location count as a place where the employee would reasonably be? Does that count for that in the course of employment aspect? And in some cases it does.
That's a great point.
And so that's another thing where, maybe there's a pretty recent case that made headlines. I think that there was a woman who had a home office in her basement, and she went upstairs to her kitchen to get a glass of water, and she tripped and injured herself going up the stairs. And so the insurance carrier's position and the employer's position was, well, she was home. That's not covered. And I believe they actually found that that was a reasonable thing for her to do. And so her injury was covered under that state's work comp laws.
Good point.
And, yeah. So that's another thing that there are some changes, but again, you don't know if they're covered. So ask, reach out. I think, an attorney is going to be able to help you help figure out some of those nuances. So then, what types of injuries are covered? So I practice primarily in Iowa, well, solely in Iowa. And Iowa has a really broad definition of injury. It's, at least in Iowa, any health impairment other than, just the normal wear and tear of aging, as long as it's related to that person's employment. I mean, Iowa law will cover allergies that cause, maybe caused by something in your office or your place of employment, insect bites, repetitive trauma or cumulative trauma. So if you are working somewhere where you are regularly bending over, that's part of your job. You're bending over, picking something up, and you're doing that all day long, through your job, and you become, or you develop back issues. That's a repetitive or cumulative trauma, and it's probably covered in Iowa. All states are different, but I think that that's probably pretty representative of the laws in general. I will say pre-existing conditions are not typically covered. So if you have a back injury from, a few years before you were employed, and then you notice that it's getting worse, it may or may not be covered. But if your job does something that would aggravate that or worsen that back pain, then it might actually be covered. So again, there are these nuances with the laws and what's covered and what's not that, I always say, reach out and ask somebody, talk to an attorney. I mean, not just Joe off the street, but reach out to somebody who knows, because what you may not think is covered or what you don't think is covered could actually be covered by your state's work comp laws.
The other thing that we can point out, another good reason as to why you need to contact an attorney on these issues is what Clarissa just kind of pointed out in passing. When you have a situation with a pre-existing condition, and then because of the nature of your job, you aggravate that pre-existing condition, well, the pre-existing condition isn't covered, but what has been aggravated may well be covered. And then there's it gets a little complicated because you have to determine, well, what portion of that injury or that aggravation is covered, and how do you separate compensation for what was really a pre-existing condition versus what is the aggravated condition now because of your work-related activities. And that can get to be very confusing and really does require the assistance of an attorney. A good example, Clarissa had mentioned the stooping and picking things up, the repetitive motion that can cause some back issues. But another very common example is someone who is doing a lot of typing and develops carpal tunnel syndrome. That is something that comes from repetitively, pounding away at that keyboard and can be very painful and typically results in a procedure known as a carpal tunnel release or other types of procedures that will be covered. And in some instances, you may have had, a pre-existing condition with respect to that type of pain. But if you are then aggravating it by typing all day, there's still probably going to be a portion of that injury that can be compensated under work comp. So, make sure you talk to somebody.
Absolutely. And you talk about an apportionment or portioning that out. Some states will say, yes, we need to figure out how much of this is attributed to that pre-existing condition, or, maybe it happened with a previous employer. Some states will just say, nope, you hired that person as is, And, much like sometimes you're buying something, but you've hired this employee. This is how they are when they came on the job. And so it's reasonable that their job caused these injuries. You're responsible for all of it. So again, another reason to reach out and speak to somebody who handles these on a regular basis.
Yeah, for sure.
Yeah. So then, so let's say you meet the qualifications, you're an employee, you've been injured. It's an injury that arises out of and in the course of your employment. So then what? What do you do next? The first thing you need to do is alert your employer. A lot of states, I think actually all states, have what's called a notice provision. So you're responsible for giving notice to your employer that you were injured while working. The timeline for doing that differs among states, but the sooner you do it, the better. And that's for a couple of reasons. One, it means that you don't miss that deadline and your employer's like, well, we had no idea that it had happened. So how could we be responsible, and take care of that medical care and treatment? But the other thing is you've been injured. You need prompt medical care and treatment. And so notifying that employer that something has happened is going to, usually ensure that you're getting the appropriate care and treatment when you need it, and not down the line potentially, making your situation worse. Right. So you notify your employer. They will usually make you fill out some paperwork, an incident form of something, and that's fine. That's to protect you. It protects them, but it also protects you because it's a documentation that you informed them that you were injured. And then hopefully, in a good case, and this is, I think, more common, I don't think that employers try to avoid their responsibilities and providing care and treatment, but then they send you to usually an occupational health or an occupational health physician or provider that they've contracted with to get you evaluated and determine what type of treatment or care you need.
Clarissa, let's, as you mentioned, in Iowa, the definition of what is covered under work comp is one thing. It's a little bit different in other states. But in many instances, it's not simply a physical injury that is covered. It could also be an illness, right? So let's say that you have some kind of illness that you either is not diagnosed for some period of time. It could, because obviously you may have contracted that illness at one point in time and not even know until further down the line that you had the illness, and or, for instance, mesothelioma is a good example where you can only contract mesothelioma when it is you had exposure to asbestos, which does occur in a lot of jobs, but you may not have contracted or become aware of it for years. So this notice requirement, how does that work when you're not even able to discover, the fact that you had an illness, let alone notify someone within what would otherwise be the period of time that you have to notify someone?
Sure. So excellent question. When you have a case like that where you don't know right away, it's not discoverable, we have something that we call the discovery rule. And so it's when you discover that your illness is connected to your workplace. So if in your example, you don't discover that you have mesothelioma until, maybe 10 years down the line, and you can actually, in some cases, know that you have that. But if you don't know that that is caused by your job, then that clock for that notice provision doesn't kick in. It doesn't kick in until you know that your illness is connected to your employment.
No, or reasonably should
or
have
reasonably,
known.
yes.
Right. Mm-hmm.
Yes. And so you're exactly right. You may not know, but you're not out of luck because you didn't know or give them knowledge of the injury at the time that it occurred.
Okay.
And that kicks into your statute of limitations because if you're injured on the job, let's say it's an actual injury, maybe you've injured your wrists when you have carpal tunnel syndrome. If you know that and you know that it's related, you have a set amount of time, depending on your state's laws, as to when you can bring that claim against your employer for care and treatment. It varies from state to state. In Iowa, it happens to be 2 years. There are some circumstances that change it, but it's typically around that time. Sometimes it's 1 year, sometimes it's 3. But you have the main takeaway from this is that you have a set amount of time to bring any potential claim. And so that's another reason why that notice to your employer is so important. And but again, you have that time frame. But if you don't know, as Dennis said, that's when that discovery rule kicks in and can sometimes extend your statute of limitations. But again, that's something that I don't know that I would want to just rely on, maybe a Google search. I would want to talk to somebody who practices that, because there are, always exceptions to the rule.
And there's a distinction, is there not, between the notice and the statute of limitations?
There is, yes.
Yeah, and you have to get that notice much sooner than you're required to actually file your work comp claim.
Yeah.
So you can have the 1, 2, or 3 year statute of limitations in which you have to actually file your work comp claim, but preliminarily you have to actually notify the employer of your injury or illness within that shorter time frame.
Yeah, and it's usually just a few months. So in Iowa, it's 90 days. You have roughly 3 months to let your employer know. In some states, it's 120 days. It might even be 180, but it's a very short amount of time to let them know. Mm-hmm. And then, the statute of limitations for bringing that claim later is that 1, 2, or 3 time period, depending on your state.
This, and I don't want to get too far ahead of ourselves here. You might already have planned on discussing this, but this seems like a good point to also bring up. A fear that I know a lot of employees have in bringing a claim is that there's going to be some kind of retribution from the employer because you're bringing a claim, and that's, employers may think, oh my, that's going to really screw up my comp premiums, et cetera. What, if anything, can be done if an employer kind of takes it out or retaliates against a employee for filing a work comp claim?
Sure. Excellent question. We get that a lot. And it's an understandable fear. It depends. I hate doing that. That's the lawyer answer. It depends, but it really does. It's based on your state's individual laws, but at least, and again, it depends on whether or not you're in an at-will state or not, because they'll use different, if you are, they will find different ways. But in general, terminating an employee or retaliating against an employee is something that goes against, or for bringing a work comp claim is something that goes against public policy. And it's really frowned upon, and you may have a separate claim against your employer if that's something that they do. But again, it's state specific as to how that happens. Sometimes there are, again, notice provisions for bringing that potential claim. So if you think that is happening to you because you've been injured and have filed a claim for your care and treatment and whatever you're entitled to, I'd strongly encourage you to seek out the advice of an attorney to see if that's something that you're entitled to, because again, there are timelines here that have to be met.
Right. And with respect specifically to being fired because you filed a work comp claim, I'll just add that in many, if not most or all states, if that's the case, if you can show that it is related to you filing a work comp claim, there is, as Clarissa alluded to, potentially a complete separate cause of action against that employer for what's called retaliatory discharge, meaning that you were fired in retaliation for filing your workers' compensation claim. So now, in addition to having that underlying workers' compensation claim, you potentially have a claim against your employer for firing you, for pursuing that comp claim. So it's something, again, that I felt was timely as far as our discussion here to bring that up.
Yeah, no, absolutely. And it is a common concern and fear among people who are injured. And I get it. I mean, nobody wants to be injured, unable to work or not able to work to the full extent that they would, and then suddenly find themselves without a job. You don't need that added stress. Right. So, so you've been injured. You've told your employer. Now what? It depends. So some states require the employer, I take that back. Your employer is responsible for your medical care and treatment. Let's say we've established that. Who do you see? Which doctors do you go to? In some states, because the employer is paying for the medical care and treatment, they get to pick the doctor that you go to. That's the way it is in Iowa. So let's say that I'm having carpal tunnel issues and I need to see a hand surgeon. My employer would get to choose who I saw. They get to pick the doctors. They get to pick if I need physical therapy, if I need surgery. They can pick the hospital that it goes to. They get to make those decisions.
And from a practical standpoint, when you say they, meaning the employer, isn't it usually the work comp carrier that's making those decisions?
It's the work comp insurance carrier. I find that the actual employer typically has no idea who their employee is being sent to. It is really the insurance carrier that's making those decisions. But they do get to make those decisions. However, there are some states, I think Illinois is this way, where they're responsible for the care and treatment, but the injured employee gets to pick who they go to and who they see. And if they need surgery, they get to pick the surgeon and what hospital. Again, it's really state dependent. But I think the important thing is that it's the employer and that insurance carrier who is paying for that medical care and treatment.
And I'll just add that in those states, for instance, Illinois, where the employee is able to select where they're getting their care and treatment, there's still usually some parameters. There's some restrictions. It's not, you can't go willy-nilly and think, oh, well, hey, I'd like a massage today. And, it's got to be reasonable and necessary. And there are limitations as to the number of selections you can make. And sometimes there is kind of a coordinated effort between the work comp carrier and the employee. So as Clarissa pointed out, it really is state specific. Again, another good reason to speak to an attorney when you're at that stage of your work comp claim, trying to get the proper care and treatment for your injury or illness.
Yeah. And because it's state specific, and that because there are differences among the states, one other reason to reach out to an attorney to talk about this is because sometimes an injury falls under two states. So if your employer, I'm going to use Illinois and Iowa because it's where I'm located and close, but if you are injured in Iowa, but your employer is located in Illinois and you work out of that Illinois office or location and just happen to be injured in Iowa, you have coverage under Iowa, but you probably have coverage under Illinois. So an attorney can help you figure out which jurisdiction is more favorable to you. And so that's another thing. Some states have more favorable laws depending on what your injury is. So that's not something that, you want to just automatically go with what the insurance carrier is telling you, because it might not be in your best interest.
Right.
So then you're going to the doctor, and let's say that you're in a state where the employer, their insurance carrier, gets to make the decisions as to who you treat with and that kind of thing. What if you don't like your doctor? Under some very specific circumstances, you may be entitled to what we call alternate medical care, where you can see another doctor. If it's just because you don't like the doctor, you think they have poor bedside manner, that's probably not going to fly. You're not going to be able to say, hey, I don't like him. I don't want to go to that person. But if you think that doctor or provider is not providing you the appropriate level of care, maybe they're just completely ignoring your symptoms or dismissing them out of hand, or they're suggesting something that really doesn't seem right, you are able to petition for alternate medical care, because not only is your employer required to give you or provide medical care and treatment, but it has to be the appropriate medical care and treatment. They can't just give you a Band-Aid and push you along and move you on your way.
Right.
And so there are different types of benefits that you get as well. So not only do you...
Oh, wait, Clarissa, I'm sorry. Before you go on to the benefits, because that's a little bit different, would it not be true also, since we're talking about, the need for appropriate care and the ability to get alternate care if you're not getting that appropriate care, would you also find coverage if your caregiver committed malpractice? So, and you ended up having to have remedial care as a result of the malpractice from the work comp caregiver.
Absolutely.
Would that then also be covered, right?
Absolutely. It's still it's arising out of and in the course of your employment. So just because they messed up, that's not, it's still related to that initial injury that you had. So yeah, that should absolutely be covered.
And this would be an extreme example, but let's say, for instance, you were injured on the job, you broke, or you had a rotator cuff tear of your left shoulder, and you went in for surgery for the rotator cuff repair, and somehow the surgeon goofed and opened up your right shoulder, and it was supposed to be your left shoulder. Well, that's a malpractice situation, and that is something that would also be covered under work comp. You might have a separate medical malpractice case against the surgeon, but you would still have a potential claim, work comp claim, for the cost of any remedial measures that have to be done because of that malpractice.
Absolutely. Okay. And just as an aside, I used to be an OR nurse, this, and you just gave me flashbacks to my greatest fear, is operating on the wrong side of somebody. So
yes, it does happen, unfortunately.
It does, but that was always my worst fear. So thanks for that. But yes, you're right. If there is, if they committed malpractice while taking care of you for your work injury, that absolutely is going to be covered. You might have to, I don't want to say fight, you might have to, give them a little bit of push back on it, but yes, that's related to that injury.
Okay.
And, you know, or maybe you've been injured, you're going to PT for your work injury, and you are in a car accident on the way there and have other injuries. Sometimes that's covered depending on, you know, were you definitely going there? Were you making a little detour? But depending on the circumstances, that could also be covered.
Right.
So you have that claim against that other driver, but also through your job. And I guess before I start on disability benefits that you're entitled to, it's, you know, we talked about like actual injuries. You know, maybe you've tripped and sprained your ankle or broken a leg or something, or you've got this cumulative injury with the carpal tunnel. But it's not just physical injuries. There are mental injuries that occur as a result of your jobs as well. So, you know, perhaps you are in a setting where you see an employee or a fellow coworker who is seriously injured or even killed on the job, and you have some, you know, mental injury. You know, maybe you now suffer from anxiety because of this, or depression, or even, you know, you're eventually diagnosed with PTSD. That is potentially covered under work comp. So it's not just the physical injuries, the mental injuries that you have as well from your job can potentially be covered. Not all of them though. So just the regular stresses of your job, probably not going to be covered. If, you know, your boss yells at you, like Dennis yells at me every day. I mean, he doesn't, but if your boss yells at you, that's probably not going to be covered under work comp laws. But there are some circumstances where it might be. So that's another thing to just not just assume, well, it's not physical, so it doesn't count or it's not covered.
Mm-hmm. Right.
But moving on to the different types of benefits that you get. So yes, your employer is responsible for covering that medical care and treatment, but what happens if you're off work? So you've injured your shoulder and you need to use your example and you need surgery for that. And then you're off work for, you know, 8 to 12 weeks after that. You're not working. So you're not you're not punching that time clock. You're not bringing in any income there. Well, your job is responsible for covering and providing you weekly benefits to cover those missed work and those wages that you're losing out on. Again, it's state dependent, not just the amount, but when those benefits are owed. So if you are off work for some states, it's 3 days, some states it's 7 days, your employer may not be required to cover those initial few days of missed work. But if you're in one of those states and you're off work for an extended period of time, they might have to go back and pay you. And again, it's just state dependent. In Iowa, it's the first 3 days. So if you're off work for 3 days, they don't have to pay you for those missed days. But if you're off work for, 10 days, they'll pay you beginning on day 4 through day 10. And so you'll get some amount of payment. If you are off work for, let's say, 3 weeks in Iowa, they will initially just pay you beginning on day 4. But once you hit that 14th day, they'll go back and pay you those initial 3 days. So it's dependent. It's really dependent on states. Some states are 7 days. Some states are 10 days. It just depends. But if you're off for an extended amount of time, you're typically going to get some sort of weekly benefit to make up for those wages. The caveat, though, is that it's not going to be your full wages. So if you're making, $800 a week or taking home $800 a week, you're probably not going to get that when you are off work. It's usually based on a very complicated and sometimes subjective calculation as to what you are going to get. In Iowa, at least, it's based off of your average gross weekly wage. So your average weekly wage before any deductions are taken out. And so once we have, and we look at the 13 weeks that represent your injury, but we look at a specific time period to figure out what that average gross weekly wage is. And then we have a spreadsheet that's published yearly, and we look at a lot of different factors. So the wage, we look at whether or not you're married. Are you single? Are you married? We look at whether or not you have dependents. So, and not just necessarily children, but maybe you are responsible for a sibling, but you can claim them as a dependent on your taxes. Or maybe you have a parent who depends on you and is a dependent. So those are other things that we look into. And so those factors can increase the amount that you would get in those weekly benefits.
So in this formula that you're referencing differs from state to state as to what amount
it does.
You're going to get as far as your benefits, your work benefits. Is it also dependent upon, or does it depend at all on how you are identified either as a permanent or temporary disability, or does that come into play with something else?
That comes into play later on. Mm-hmm. So what it will do, and a lot of times we get these questions about the compensation, is, well, I'm only part-time, so I didn't really make that much. Well, we look at their specific calculations. So these are things that we do take into consideration. And you're not going to, if you're part-time, you're not going to suddenly bring home what you would have brought home if you were full-time, but we take that into consideration. Or if you are a temporary employee versus a permanent employee, those are things that we look at. But your actual injury itself and whether it's permanent or temporary, that's something that gets looked at down the line.
Right. Okay.
And so, talking about those permanent or temporary disability benefits. So the benefits that you're getting while you're off work are typically classified as temporary benefits, because the goal is to get the injured employee back to work, back to their, baseline health level and back to work so that these injuries aren't permanent. Unfortunately, that doesn't always happen. So, maybe I break my leg while I'm working and it's a covered injury. And I've gone through treatment. Maybe I had surgery. I've done physical therapy, and the doctor says, you are at maximum medical improvement. That's a term that gets thrown out a lot in work comp, MMI, maximum medical improvement. And all that means is that you're not necessarily back to 100%, but you're as good as you're going to get with respect to that injury, that work injury. Right. And so when you get to that point, MMI, oftentimes we get an impairment rating to determine, okay, you're not back to 100%. So what is the impairment? What is that permanent disability that this injured employee can look forward to for the rest of their life? And so that when we get that impairment rating, we use in Iowa, most states use the AMA guides. It's this big book right here. We use the 5th edition, but you look at the injury that you had, what part of the body it affected, and what you can or cannot do. And that's how those doctors get those impairment ratings to determine that level of permanent disability. Right. And so once you have that, so you've gone through treatment, you've been injured, you've told your employer, you've gotten the care and treatment that you need. You've been deemed at maximum medical improvement. You now have an impairment rating. What happens next? Well, typically, the insurance carrier, using that impairment rating and your average weekly wage that you've been getting for your weekly benefits, if you've been off work, they will calculate that, and then they'll look at the body part that's affected and determine what level of compensation you are entitled to. And so then using that, they'll say, okay, well, here, a lot of times they'll say, well, you're entitled to this. So here's, the $3,500 that we owe you for this disability. And they'll wash their hands of the situation. They're done. And that is when that happens. If you don't have an attorney at this point, and you haven't had one involved, get an attorney, because you're oftentimes entitled to a second opinion. So that impairment rating might be low. And so you can get a second opinion. In Iowa, the insurance carrier is responsible for reimbursing you, that as long as it's related to work. They're responsible for reimbursing you for that second opinion. And that second doctor might say, well, actually, I think your impairment rating is a little bit higher, or maybe even a lot higher. And also, getting an attorney involved will double check that rate to make sure that it's the correct rate, that they've taken into consideration all of the necessary factors. And so that's when you are, potentially going to get even more compensation for this injury that happened while you were just trying to do your job.
And, since we're talking about, bringing in an attorney to help you either get a higher impairment rating or a recovery of some sort, and sometimes even to get the work comp to pay those medical expenses and or the work, the salary benefits or the wage benefits. How is an attorney compensated for that work? Sure.
So we work on a contingency fee basis. So we don't get paid unless we get you some sort of recovery at the end. Contingency fee basis is if we get you money or a recovery or settlement of some sort, we get a percentage of it. And that's that's in your contract. It's specific to the law firm and the contract that you sign.
Right. And in certain states have certain caps as to what that contingent fee will be.
Yeah, and they have done that because they don't want. They want to make sure that the injured employee gets a portion. Their recovery. They're entitled to. Mm-hmm. So you're right. There are definitely caps. I don't think they're unreasonable caps. It's pretty standard. And then, but there are expenses during the process that we incur, but we pay those out of pocket. You don't have any out of pocket costs. It's just at the end, if I had to order medical records that I couldn't get, through the insurance carrier, and the provider has charged a fee for those, then we'll keep track of those costs, and that will come out of any settlement at the end. But we do it in such a way that we try to keep costs as minimal as possible. We try to do things in the most cost-effective and cost-efficient manner possible, because at the end of the day, I want you to go home with the highest amount of money possible. I want you to get the highest recovery possible. And I have a responsibility to you, if you're my client, to make sure that I do that. And so one of the ways that we try to keep costs down low is work comp insurance carriers, when they're paying for your treatment, they are getting those medical records after every visit. They're ordering them regularly. And they're supposed to give them to you afterwards if you ask. And so that's how one of the ways we keep costs down is, instead of ordering those records ourselves, we get them from the insurance carrier. Sometimes we have to hire experts But again, we try to find the best expert, but at a cost efficient and cost effective rate to do that. And with that second opinion, those after you get an impairment rating, depending on your state, the insurance carrier and the employer is responsible for reimbursing that. So that's another way that we keep costs down, is that's an expert that we use that, we hope would be favorable to the employee, but it also keeps the cost down.
Another area that I'd like to touch on before we wrap up is, we had described scenarios where you might have a work comp claim, but you might also have a third party claim against someone else. So, for instance, the example that I raised where you were going for care and treatment for a work related injury, but medical malpractice occurred. Or, as Clarissa pointed out, you were heading somewhere and perhaps you were in a car accident and the other driver was at fault. Well, in those instances, you might have a claim against that driver. You might have a claim against that surgeon, in addition to your workers' compensation claim. So, the nice thing about workers' compensation, as I alluded to earlier, is you don't have to prove anybody was at fault. You don't have to prove anybody was negligent. All you have to do is meet the criteria that Clarissa laid out, that you are an employee as defined by your state, that you that the illness or injury occurred in the course of or in furtherance of your employment. You made proper notice, et cetera. You did all those things. That's all you have to do. You don't have to prove that you were blameless. In fact, a lot of people are hurt and they were the cause of their own injuries. You don't have to prove somebody else was at fault. But, as a result of the trade-off there is that when you are compensated under workers' compensation, you get your medical benefits, you get your possible impairment rating, you get your wages, et cetera, but you don't get compensated for things like pain and suffering, disability, scarring, things of that nature that you might be entitled to if you have a claim that includes a negligence claim. So the scenario that I'm referencing where you have a third party claim, meaning you have a case against somebody else besides your employer, you can get a recovery from that doctor. You can get a recovery from that other driver. But then when that happens, if work comp has also paid you, you have an obligation to pay them back, or at least a portion of what they paid out to you in work comp benefits. If you're getting a recovery from the responsible party, the person who injured you, then the comp carrier is entitled to some reimbursement. And that, again, is where having a lawyer on your side can be very beneficial, because they can negotiate with that comp carrier to get them to take less than they might otherwise be entitled to. Because for one thing, they're reaping a benefit from you having hired an attorney, so they have to take a discount right away, which constitutes their pro rata share of attorney fees and costs. And then there are other issues that might come up with respect to convincing them to waive or reduce the amount of the fee that they're entitled to, or the amount of the recovery that they're entitled to, because as Clarissa pointed out, they just want to get it off their books. Yeah. If you can get them to agree to, hey, this is what you've paid, my client might be entitled to, or you as the injured party may be entitled to further workers' compensation benefits down the road. But now that you've got a bigger recovery coming in from a third party who is responsible for the injuries, they may say, listen, if you tell us we don't have to continue with your paying your benefits down the road, we're going to waive anything you owe us. And that's something that an attorney may be able to negotiate for you and end up getting you kind of a windfall. It's not really, because you're entitled to it by all means, you're entitled to that kind of recovery, but it is a bit of a dividend having the attorney there to negotiate that.
Absolutely. Absolutely.
So, and I didn't want to step on anything that you were presenting, but I wanted to make sure we brought that up. Any other thoughts, Clarissa?
No, that was actually my last thing to discuss.
See, I did step on it.
It's okay. It's okay. It's okay. You did an excellent summary.
Well, and I appreciate that, because Clarissa is certainly our work comp expert in Iowa. I know work comp simply from being around it for 30 some years. It's not my main area of focus, but because I do those third party claims, I do a lot of that type of work. I have to deal with work comp carriers all the time, and of course with work comp injuries that may have arisen where there is a third party claim. So it's not uncommon for law firms to have departments that focus on work comp and others that focus on the third party injury claims. It's probably more common in smaller firms where you have one attorney who does some of both and maybe does some general practice and whatnot. And I just want to make sure that you, if you are injured on the job, that you are aware that you have these options as far as attorneys. I certainly don't want to suggest that a general practice attorney cannot handle your workers' compensation claim. But the practice of law in a lot of ways is a lot like the practice of medicine. There are generalists, and then there are people that specialize. So, in medicine, you have family practice doctors who are generalists, and then you also have orthopedic surgeons and neurologists, et cetera, who focus on a specific area of medicine. In law, it's similar. There are general practitioners who do a little bit of a lot of different things. They might do a real estate closing. They might handle a traffic ticket or a criminal defense matter. They might handle a work comp or a car accident. And they are proficient at doing a lot of those things. But then there are also attorneys who focus almost exclusively on one area or another. At Vandergans Law, we focus on all areas of injury law, including workers' compensation and these third-party claims. So we're fairly confident that we can handle anything along those lines for you. And we're certainly honored to help if you have any questions when you're in a situation like this. But we don't want you to think that you can't talk to your uncle or your cousin or whomever it might be who's a general practitioner, because they may be fully capable of handling a work comp matter, especially if it's kind of a straightforward, simple matter. But if it is more complex, more complicated, you may want to reach out to a firm like ours that does focus exclusively on these areas.
Yeah, absolutely. And especially because I think most firms offer that free initial consultation. So you're, reaching out to somebody who has experience. I know our firm does that, but you're not anything out of pocket. So what do you have to lose but maybe, 15, 20, 30 minutes of your time?
Right. Well, anything else to add, Clarissa, before we wrap things up?
No, I think that's it. Thank you for having me, though.
Well, thank you, Clarissa. Great job. Great presentation. And everyone else, thank you once again for joining us. Be sure, if you haven't done so, as I already mentioned, if you haven't subscribed yet to Legal Squeaks, please do so on any podcast platform. It's free and it's easy. And when you do that, you get, a notice as to when the next episode drops, and you help us out a great deal. So we would appreciate it. We'd also appreciate it if you'd check out our other podcast, Uncommon Convos. You can also find that on your favorite podcast platform. With respect to both Uncommon Combos and Legal Squeaks, if you'd like to watch the video version of these podcasts, you can either go to uncommoncombos.com or you can go to legalsqueaks.com. You can actually watch this video or the video from this podcast at that website, as well as every other episode that we've done. You can also suggest topics for future episodes, and we'd certainly love to hear from you. So please make sure to check us out next week on Legal Squeaks. And in the meantime, have a great day, a great weekend. Stay safe, and I love you all.